We have some breaking news for you today in the Karen Reed case. So we are going to go through this opinion that just came out in the civil case. But first, let me just remind everybody where we are in the Karen Reed case so that we can be better prepared for our reading of this opinion. So Karen Reed, we know, has a criminal case going on, which is currently at the Supreme Court level, waiting to hear arguments on the double jeopardy issue. And there's also a trial scheduled for January 27th, 2025. And at the same time, she has a civil case going on where she is being sued by the O'Keefe family and the estate for John O'Keefe. So she's being sued in that case civilly for money damages, along with C.F. McCarthy's and the Waterfall. C.F. McCarthy's and the Waterfall are being sued for dram shop. Karen Reed's being sued for wrongful death. So you have two different cases going at the same time. Now, generally speaking, like we spoke about previously in our previous videos about this case, in the civil case, when you file a complaint and you serve it on the defendants have a certain amount of time that they need to answer the complaint. So every single paragraph in the complaint, it's laid out 1, 2, 3, 4, 5. The defendant has to file an answer, also 1, 2, 3, 4, 5, admitting, denying, or saying that they do not have enough knowledge to either admit or deny, and they're going to have to figure that out during discovery. So that's generally what happens when a defendant is served with a complaint. They have to file an answer. If they don't file an answer, they can get defaulted. Not good stuff for the defendant. So never ignore legal papers, okay? That's one of the lessons here. But anyway, so Karen Reed got this lawsuit served on her, and her attorneys, what they did is they filed a motion. Now, you don't have to answer a complaint, because you could also file a motion. One very common motion is you can file a motion to dismiss. That even if we were to accept all the allegations that are made in the complaint, you still have not stated a recognizable cause of action. You could do that instead of answering the complaint and wasting everybody's time and going through the whole discovery process. You can respond right away with a motion to dismiss. In this case, Karen Reed's attorneys filed a motion to stay the civil proceedings. Now, I thought that perhaps they could really file a motion to dismiss some of the counts, but they don't want to get involved. They want just everything to be stayed, and then they'll figure out what to do with this case after the stay is lifted. So the reason why they want the proceedings stayed is the following. We all understand that there's a Fifth Amendment right that every defendant has to remain silent. And the fact that a criminal defendant remains silent, his silence cannot be used as any sort of inference against his innocence. And that is a common jury instruction that the judge gives the jury, that if the defendant chooses not to testify, you should not read anything into the fact that the defendant is choosing to remain silent. He has a Fifth Amendment right to remain silent. But when it comes to a civil case, if you decide to invoke your Fifth Amendment right and remain silent, not answer any answers in depositions, or not take the stand, well, then there is an adverse instruction, an adverse inference instruction that's given to the jury. So what should Karen Reed do in this situation? She's got a criminal case coming down in a few months, and if she starts giving a deposition, they can get some really juicy stuff that they can use in her criminal case. So what is Karen Reed supposed to do in this case? If she invokes her Fifth Amendment right in the civil case, well, then her civil case is going to look not so great for her, because she's not able to then explain and deny the charges or the complaint, at least civilly, and it's going to be an adverse inference against her. But if she speaks, so then they can start using that in their criminal case. So it could be used as a very sneaky way to get around the Fifth Amendment privileges. So either you're going to ruin your civil case, or you're going to give a deposition in the civil case, and then they can start using that in the criminal case. So that is the issue here. So that's why Karen Reed's attorneys asked for a stay of proceedings. Now, you would think, and as we've explained this already in our previous videos, you would think that, the Fifth Amendment right is so important for a criminal defendant, so then, yeah, they should automatically stay all the civil proceedings. But it's not that simple, because why should the plaintiffs have to wait for, who knows, maybe 3 years before this trial gets underway, and they're sitting there waiting just because you're protecting the defendants' the Fifth Amendment rights, but these plaintiffs also have rights. So all of this has to be weighed, and there's case law in Massachusetts which discusses how you have to weigh these type of factors. When you are allowed to grant a stay, when should you deny a stay, and those type of things, like those type of factors that a judge should take into consideration. So this motion was filed by Karen Reed's defense team in the civil case, and there was responses by the O'Keefe family. Obviously, the O'Keefe family wants the case to go forward. Now, something that I pointed out in one of my previous videos about this specific issue was the fact that it's hard to imagine that this was all just an accident, because they scheduled her deposition for December of 2024. Okay, now discovery is when, during the discovery phase, is when you can take depositions. The discovery phase here ends in August of 2026. That's what it, if my memory serves me correct. So you have so much time to take her deposition. Why are you scheduling it for right before her murder trial? It seems that there's something else going on. It seems like you're actually trying to use the civil system against Karen Reed. That's what it seems like. So again, of course, you can argue, no, this is just as part of the normal process. We always schedule our depositions right away, especially if the plaintiffs, before interrogatories are served, before any other documents are requested and subpoenaed and things like that. We always, I'm sure you can hear arguments like that. And I'm sure if you'd ask them, that's probably what they would say. No, we just want to get our deposition done right away. Even though, reasonably, very often the deposition of the plaintiff doesn't happen within the first month or two of the case being open, or of discovery being open, many, many, many times. So there could be some gamesmanship behind this. Nevertheless, right now they scheduled her deposition for December. And when I say they, I mean the plaintiffs in this matter. And Karen Reed's team filed a motion to stay and therefore put everything on pause. So now let's see. And of course, obviously the O'Keefe family opposed the stay. They say, no, it's not fair. We want to give the family their rights that they have to money damages against Karen Reed because she allegedly hit him with the car. We already know all the interesting facts in this case. So this finally is what the judge ruled in this case. So that kind of just set the stage. And now we're going to go through what the judge's opinion is. And this is really hot off the press. I just got this right now. And hopefully maybe you might be the first people that are actually able to see the opinion. So that's why you got to always follow Brother Counsel. Before we jump into the opinion, of course, I want to give a shout out to the sponsor of this video, The Suit Depot. Their link is in the description. Go check out their website for very high quality suits and apparel and very reasonable prices. And of course, my listeners, they get a 10% discount off everything you purchase. Just type into the coupon code box, Brother Counsel, all lowercase, no spaces, and you will get 10% off your order. The link is in the description. Let's jump into the opinion. So here we go. This is the opinion that just came out. And here we go. Memorandum of decision, yada, yada, yada. This is the order. Okay. The estate and some of the surviving relatives of John J. O'Keefe III O'Keefe filed this action against C.F. McCarthy's Waterfall Bar and Grill and Karen Reed, alleging wrongful death and negligent and reckless infliction of emotional distress. We, by the way, went through each of the counts in our other videos. If you haven't seen that, go check that out, because some of the counts may be completely gone very easily. And some they may actually be able to get into the discovery phase. Whether they actually have any merit or not is a different question at all, completely, because as we said, it all comes down to the experts in this case. And unless they get experts saying that there's some sort of scientific explanation how the injuries on John O'Keefe match Karen Reed's car, then they're going to have a real problem winning the civil case, as I explained already in previous videos. All right, so let's move on. For the reasons discussed below, the defendant's motion to stay the proceedings pending the resolution of the criminal trial against defendant Karen Reed are allowed in part and denied in part. So he granted it in part and denied in part. Very common for the judge to do this. He'll say, you're asking too much, but we'll give you a little bit. So here's the background. The plaintiffs filed this action on August 26th, 2024. Their complaint alleges the following facts. CNC Hospitality LLC and GNS Hospitality LLC own and operate C.F. McCarthy's restaurant in Canton, Massachusetts. Waterfall Bar and Grill Ltd. owns and operates the Waterfall Bar and Grill in Canton. Karen Reed was in a dating relationship with O'Keefe. On January 28th, 2022, Reed arrived at C.F. McCarthy's around 8:51 p.m. Between 8:58 p.m. and 10:29 p.m., the restaurant served her 7 alcoholic beverages, which she drank. Now, before anyone starts jumping about, was it really 7 alcoholic beverages? Who says? The video's not so clear. Maybe she only had a few. Okay, they're just, the way that the judge is doing this is he's just adopting whatever the plaintiffs allege in their complaint just for purposes of this motion. He's not ruling on this. He's not saying that this is actually what happened. He's just adopting what the plaintiffs put in the complaint as though it's true, even though he's not making any sort of finding about that. Okay. All right. So let's move on. Reed, who showed signs of intoxication while at CF McCarthy's. And again, of course, it's very hotly disputed whether she had any signs of intoxication. I think from the videos, it just seems that she's happy, having a good time. But anyway, let's just, again, they're just adopting what the plaintiffs put in the complaint. So again, Reed, who showed signs of intoxication while at CF McCarthy's, left around 10:40 p.m. carrying an alcoholic beverage out of the restaurant. Reed and O'Keefe entered the Waterfall Bar and Grill around 10:54 p.m. Reed was carrying an alcoholic beverage from CF McCarthy's and showed signs of intoxication. Between 10:54 p.m. and 11:54 p.m., Waterfall Bar and Grill served Reed one shot and one mixed alcoholic beverage, which she drank. Reed and O'Keefe left Waterfall Bar and Grill around 12:10 a.m. on January 29, 2022. The plaintiff's complaint alleges the following additional facts. So again, he's saying it pretty clearly. The plaintiff's complaint alleges the following facts. Reed was under the influence of alcohol and unable to safely operate a motor vehicle. It was snowing and there was an impending blizzard. Reed drove O'Keefe to a residence at 34 Fairview Road in Canton. After O'Keefe exited the vehicle, Reed drove her SUV into O'Keefe, knocking him to the ground and causing him serious injuries. Reed then fled the scene and returned to O'Keefe's residence at 1 Meadows Avenue in Canton, leaving O'Keefe on the ground in the blizzard. O'Keefe died from his traumatic injuries and hypothermia at 7:50 a.m. on January 29, 2022. Reed's blood was drawn that day and read 93 milligrams per DL, which extrapolates to a blood alcohol level of between 0.13 and 0.29 at the time she hit O'Keefe, which is obviously over the limit. Counts 1 through 3 of the complaint allege wrongful death against CF McCarthy's Waterfall Bar and Grill and Reed, respectively, and counts 4 through 9, 10, 11, 12 allege negligent, reckless, and intentional infliction of emotional distress. In connection with O'Keefe's death, Reed has been charged in Norfolk Superior Court docket number, which with second-degree murder, manslaughter while operating under the influence and leaving the scene of an accident. So that is what she's being charged in the criminal case. Following a criminal trial that ended in a hung jury on July 1st, 2024, Reed is scheduled to be retried in Norfolk Superior Court on January 27th, 2025. So she is scheduled to be retried on January 27th, which is about another 2 months. In this civil case, Reed has not answered the complaint. Instead, she moved to stay the proceedings. According to the tracking order, discovery will not close until August 17th, 2026. So there you go. Discovery is not going to close until August 2026. What is the emergency to get her deposition in December of 2024? Right? Okay, but anyway, and no trial date or pretrial conference date has been scheduled. So there's no trial date scheduled. There's no pretrial conference date scheduled. We have so much time till August 2026 when discovery closes. The plaintiffs have noticed Reed's deposition for December 4th, 2024. What a coincidence. All right, now here's the discussion. Reed moves to stay this action on the ground that her Fifth Amendment privilege against self-incrimination would be impacted if the wrongful death case proceeds while the criminal prosecution is ongoing. This is what we explained. Her Fifth Amendment privileges are being impacted here. CF McCarthy's and Waterfall Bar and Grill also moved to stay this litigation to preserve the resources of the parties and witnesses and promote judicial economy. So CF McCarthy's and Waterfall Bar and Grill, also, they're separate parties. They also joined this motion of Karen Reed to stay this proceeding as well, because they wanted to preserve the resources of their parties and their witnesses, and for the promotion of judicial economy, it makes sense for just everything to be stayed until the criminal case has concluded. All right. So really, there's 3 parties that the judge has to address when he's making a ruling about this motion. A stay of proceedings in a civil case pending the resolution of a parallel proceeding is addressed to the court's sound discretion, which means that it's completely up to the court. There's no requirement that a judge has to do one thing or the other. A court completely has the discretion to either issue a stay or to deny a stay. It's completely up to the judge. However, the court must give serious consideration to the reality that parallel civil and criminal proceedings significantly burden the Fifth Amendment privilege against self-incrimination. As we've explained, to have the civil case going on, and you don't want to lose your Fifth Amendment privilege when there's also a criminal case going on, it's going to impact it, because if you stay quiet, then that can be used against you in the civil lawsuit. If you don't stay quiet, well, then they're going to hear everything that you have to say in your deposition in the civil case, and then they can use that in the criminal case. Participation in the civil case poses the danger to the defendant of an increased likelihood of conviction at the criminal trial by self-incrimination through exposure to cross-examination. Right? That's what could happen in the civil case. If you're exposed to cross-examination, it could be that you'll eventually incriminate yourself. Despite the strategic dilemma posed by parallel proceedings, the refusal to stay a civil case pending the outcome of a criminal prosecution does not violate due process. So it's not an automatic violation of due process if the judge decides we're not going to stay the proceedings. It's very clear. The judge can say, we're not issuing a stay. There's no violation of due process, and we're continuing. Even where the defendant's refusal to testify in the civil case creates an adverse inference against her. Like we said, if you refuse to give testimony in the civil case and you invoke your Fifth Amendment right, well, in the civil case, that will create an adverse inference against you. And that is a jury instruction that can be given in the civil case. And then he quotes some cases here. From this case, party in civil proceeding who faces criminal charges is not entitled to have judge accommodate both her desire to testify and her desire to remain silent. And again, another case, United States Trust Co. of New York versus Harriet, there is no constitutional requirement that civil proceeding must yield to criminal one. In deciding whether to enter a stay, the court must balance the competing interests at stake based on the particular facts of the case. So the court has to balance the interest, the competing interest. What are the different competing interests? The interest of the public and the parties in the timely and fair adjudication of a civil wrong. That's one thing they have to weigh. Any prejudice to the civil litigants from a stay, and the potential harm to the defendant from being compelled to choose between defending herself in the civil action and protecting herself from criminal prosecution. That's also an interest that has to be weighed. The party seeking a stay bears the burden of establishing its necessity. So this is Karen Reed, C.F. McCarthy's Waterfall. You have the burden of establishing the necessity of a stay. The estate undoubtedly has an interest in the expeditious resolution of this wrongful death case. That's no question about it, right? If we just take all emotions aside, all feelings about your case aside, and there is a death in a family, and they want the resolution of a wrongful death case civilly, then they definitely have a strong interest in that. So the estate here for John O'Keefe has an interest in this civil proceeding moving along expeditiously. Nonetheless, Reed's criminal trial is scheduled to commence on January 27, 2025. And based on the first trial, will likely take no more than 3 months. Her trial is not going to take more than 3 months. I think there was actually maybe 28 days of trial, but it's not going to extend more than 3 months. And again, it could be the second trial be a little bit longer. Maybe the new prosecutor is going to bring in some more experts, things like that. But the judge only has the last trial to work with, and he's saying that most likely it's not going to take more than 3 months. So now what essentially we're asking for is basically around a stay of 6 months. A stay of 6 months is reasonable and would neither violate the public interest nor, as discussed below, unduly prejudice the plaintiff. So it's only 6 months. All right, calm down, everybody. It's only 6 months. And remember, discovery is open until August 2026. And then he cites some case law here, staying civil case pending resolution of a criminal case against defendant where civil case was only 19 months old. Criminal case was scheduled to be resolved in 6 months, and delay of additional 6 months would not significantly harm plaintiff. So this is a case straight on. And again, I didn't look up this case yet, but this is a case straight on that says essentially that a delay of 6 months is not a significant harm to the plaintiff. So no problem if it's just going to be a delay of 6 months. And then some other cases here supporting the same idea. The plaintiffs claim prejudice from a stay due to the degradation of evidence. Specifically, they argue that restaurant employees and third-party witnesses may experience fading memories or become uncooperative over time, right? All this potential, these witnesses, restaurant employees, all these potential witnesses, their memories can be faded after some time. And therefore, that's a strong interest for the plaintiffs to have the civil case expeditiously, continue it, don't stay it, because we don't want people's memories to fade. So that is a decent argument. And here he quotes a case, noting that delay of depositions and discovery poses risk of irremediable loss of witness memory and lesser risk of witness unavailability for deposition or trial. But this is what his response is. This is the judge talking. Given the extensive investigation into O'Keefe's death and the completed first prosecution, the risk that evidence will be unpreserved and witness memories will fade does not appear to be substantial. I mean, come on. In this case, there was such a tremendous investigation that was already done that they've already have everything essentially. So you don't have to worry so much about witnesses' memories fading at this point. The plaintiffs further contend that delay will be prejudicial because Reed's media campaign is poisoning the jury pool, citing her October 18th, 2024 television interview with NBC's Dateline. Any influence on the jury pool, so this is the response by the judge, that what about this contention that the plaintiffs are making, the O'Keefe family, that what Karen Reed's her media campaign, it's poisoning the jury pool. That's also an interest. We don't want our jury pool poisoned by Karen Reed going on all these media outlets and talking about the case and her defenses. Any influence on the jury pool from delay can be remedied by the usual procedures employed during impanelment to ensure that jurors remain impartial despite any prior knowledge of the case. So the judge is saying, don't worry, we have our ways, we have jury selection, we have voir dire, we can talk to them about what they've seen on NBC Dateline or any other media outlet. We can talk to them, see if they've watched Brother Counsel or things like that. So don't worry, we're able to do that with the jurors. I'm not nervous about having an impartial jury. That's what the judge essentially is saying. Okay, and then he brings some case law supporting that as well. Let's move on. Moreover, because this case is in its earliest stages and the criminal case is scheduled to go to retrial in 3 months, the court will not be inconvenienced by a brief stay, and any scheduling conflict with witnesses that might arise would presumably be resolved in favor of the criminal prosecution. Even with a brief stay, the plaintiff's wrongful death claim can be litigated within the established tracking order. Like we said, the tracking order is the discovery you have till August 2026. So no reason why everything cannot still be worked out within that time frame. Now, C.F. McCarthy's and Waterfall Bar and Grill. So remember, there was the Karen Reed motion, and then C.F. McCarthy's and Waterfall Bar and Grill, they also joined in the motion as well to stay the proceedings. So they emphasized that their employees and the third-party witnesses who testified at the first criminal trial, we all remember those employees, may be subject to discovery in this trial while also having to testify in the criminal trial, retrial. So they're going to be being in so many different directions. They're going to have the civil case asking them for stuff. They're going to have the criminal case asking them for stuff. It's just going to be a nightmare. They therefore urge the state to preserve the resources of the parties and witnesses. However, the defendants have not demonstrated an undue burden on the witnesses from parallel proceedings. So now the judge is saying, sorry, C.F. McCarthy's and Waterfall, that doesn't seem too concerning to me. The defendants have not demonstrated an undue burden on the witnesses from parallel proceedings, and the court gives only minimal weight to preservation of the parties' resources. The most important factor to be weighed is the potential impairment of Reed's Fifth Amendment privilege against self-incrimination. So now we get into this factor. This is the most important factor. Obviously, Karen Reed's Fifth Amendment privileges against self-incrimination is the most important factor. After all, it is an amendment in the Constitution, right? And again, they cite a case here, court must not turn deaf ear to serious claim of privilege. The critical issues in both this civil action and the criminal prosecution are whether Reed was intoxicated and caused O'Keefe's death by hitting him with her motor vehicle, right? That is the ultimate issue. That's the issue in both cases. Did Karen Reed hit him with the car or not? And was she intoxicated? Although the restaurant's civil liability turns on whether they acted reasonably when serving alcoholic beverages to Reed prior to O'Keefe's death, their liability nonetheless depends on whether Reed hit O'Keefe with her vehicle. Obviously, again, it all comes down to whether she actually hit him with the vehicle, a critical issue in the criminal prosecution. There is thus substantial overlap between the two cases implicating Reed's Fifth Amendment privilege. That's one of the issues that you have to decide. Is there substantial overlap between the criminal proceeding and the civil proceeding? And here, yes, it's blatant. It's screaming at you that, yeah, this is the ultimate issue in both cases. Did she actually hit him with the car or not? The plaintiffs argue that by actively participating in public discourse and potentially profiting from media engagements, even though she says that she's like $5 million in debt, but okay, Reed effectively forgoes any claim of Fifth Amendment protection. And her choice to speak out starkly contradicts any suggestion that she is concerned with self-incrimination. So one of the arguments that the O'Keefe family made, or their attorneys made, by opposing the motion to stay is that, look, Karen Reed already effectively foregone any of her Fifth Amendment protection because she decided to speak out to all these media outlets. So she doesn't care that much about her Fifth Amendment protection in the first place, because she's going out onto media tours and talking to NBC Dateline. And, so, all right. So what does the judge have to say about this? And we spoke about this when we were analyzing their response, but the judge does a good job as well. As distasteful as Reed's media campaign may be to the plaintiffs, her statements to the media about the criminal case do not constitute a waiver of her right against self-incrimination. I'm sorry. That's not considered a waiver of your right. You're allowed to talk to the media and still, when it comes to the actual case, still assert your Fifth Amendment rights. So you may feel it's distasteful and you may not like it, but guess what? That doesn't mean that she waived her right against self-incrimination. So she still has a Fifth Amendment right. And then he quotes some cases here. Defendants' unsworn statements to police about crime do not waive Fifth Amendment testimonial privilege. Defendant's submission to interview with U.S. Attorney's Office and guilty plea to information do not waive Fifth Amendment privilege with respect to indictment. Okay, and then some other cases here. The court therefore must give due consideration to that weighty privilege. As noted, supra, this civil suit is only in the initial stages, whereas the criminal retrial is scheduled for January 27, 2025. So again, this civil suit is really in its infancy. It just literally started. And the criminal retrial is supposed to start in just 3 months and likely will last no more than 3 months. The prejudice to Reed from having to choose between defending this wrongful death action and protecting herself from providing evidence that might be used against her in the criminal retrial outweighs the estate's interest in the expeditious resolution of the wrongful death case. Thus, a brief stay of this action is warranted. Again, skipping a little bit. Nonetheless, a general stay of litigation generally is not the best option to the court and litigants. So the judge already said that he believes that a brief stay of this action until Karen Reed's criminal case is tried is warranted. Okay, so now what? Now what's he talking about? Well, now he's talking about a general stay. Nevertheless, a general stay, meaning if we're just going to stay everything in the civil case, that is not the best option. Nonetheless, a general stay of litigation generally is not the best option available to the court and litigants, and a stay should be tailored to avoid undue prejudice. By limiting a stay to the deferral of particular discovery, the court can allow a civil proceeding to progress as much as possible without prejudicing the litigant's interests. So now he's giving you a clue what he's about to say, but he's saying that if you just limit the stay to something in particular about the civil case and you can accomplish what you need, then that's the best option that you should pursue. It is unnecessary to completely stay this wrongful death suit to avoid impairing Reed's Fifth Amendment privilege. Rather, the interests of the parties, the court, and the public will best be served by staying only that discovery directed to Reed, pending resolution of the second criminal prosecution in Norfolk Superior Court. So you see very clearly he is saying that all of the discovery that's directed to Karen Reed, which means interrogatories, requests for production, deposition, most importantly, she is not going to be required to sit for a deposition. And therefore, here's his final order. For the foregoing reasons, it is hereby ordered that defendant Karen Reed's motion to stay civil proceedings pending resolution of the criminal trial, yada, 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 to stay be allowed to the extent that the scheduled deposition of defendant Karen Reed and other discovery from defendant Karen Reed are stayed, pending the retrial in Commonwealth versus Karen Reed. In all other respects, the defendant's motions to stay are denied. So C.F. McCarthy's waterfall, sorry, buddies, you're going to have to completely be open for discovery, depositions, everything that's included in the discovery phase. But Karen Reed specifically does not have to sit for any deposition in the civil case and does not have to produce any discovery or provide any discovery or answer any questions. She is completely going to be allowed to be absent for this civil case until her criminal case is done. So a very big win for Karen Reed in the civil case, and therefore now she has to concentrate on, number one, the Supreme Court case As we know, the Supreme Court case is still pending. What's going to happen with the double jeopardy? We already did videos on that. I kind of give you a clue about what's going to happen in that case. Most likely not going anywhere. And we're probably going to be set for a retrial in January. So looks like this the Supreme Court, they're going to have to hear the oral arguments on that and issue an opinion. And then we have the trial, the criminal trial coming up in January. So that's what it seems to be for the Karen Read situation. The civil case is put on hold as far as Karen Read is concerned, and she can just focus on preparing for the second retrial of this case in January. Well, that's going to be it for now. Please, if you haven't, subscribe, like, and we will see you next time.